Greetings, class. This is your instructor, Joshua Strawn. We're in Criminal Justice 315, and we're talking about Chapter 10, Privileged Communications. We're going to keep this short, sweet, to the point because there's not a lot of information in here that is going to really be talked about on any assignment, with the exception of the review questions. That's where I expect you to get a lot of the information and understand the information by answering the review questions. But it is tested. I do test it. There are quite a bit of examples that I'm going to use throughout here that you may hear later on or see later on. So please pay special attention to what I say in this lecture. And we're going to move really quickly because I don't want to keep you here too long on this lecture because the next one's going to be a little bit longer. So for privileged communications, I want you to understand that there are some basic rules for any privilege to apply. The first one to understand, and I'm going to summarize a little bit more of what the book, I'm going to change a little bit, but the book talks about these exact elements. The first thing is there has to be the right circumstances. The right facts have to be present. The right environment has to be present first for this privilege to apply. The second thing that has to be present is a relationship between the two, or the three, or the four, or the five, whoever is in the environment that we're trying to create the protection for. So, for example, let's look at the attorney-client privilege. As an attorney, if I talk to a client in my office, we have the circumstance, because I'm in my office, maybe I close the door, maybe I don't, but we're in my office. That's a very safe place. I don't necessarily have to have the door closed. So we're in my office, so we have circumstances that make it believe that we want our communication to be confidential. We want it to be secret. We want it to stay in the room and never leave the room. The second thing is we have a relationship that is recognized by the law, which is the attorney-client relationship. That is a relationship, a fiduciary relationship. I owe a duty of loyalty and care to my client. So that means that whatever is said now, because we've satisfied those two general principles, whatever is said now between us is not going to, I'm not allowed to talk about it again. The only person that can talk about it again is going to be my client. They're the ones who own the privilege. They're the ones who waive the privilege. Now, there are some, let's kind of tail it back a little bit. The communication is going to be limited to things that are for rendering legal services. Now, obviously, why else would I have a client in my office unless it was for rendering legal services? So that's the one thing I want you to understand. It has to be for legal services. The second thing, what's something that can pop the bubble itself? An unwanted party, an unwanted person, or circumstance that indicates there wasn't a reasonable expectation of privacy. What does this look like? Let's say, for example, let's change the office setting. We're no longer in my office. We're in the courthouse now. And we're actually standing in the hallway outside the courtroom. And people are walking by back and forth. You have attorneys, you have other clients coming through, you have judges coming through. You just have everybody walking through, passing back and forth. And me and my client are huddled together talking about the case. And we're trying to figure out what to do. Well, the circumstances show that we subjectively have an expectation of privacy. And the circumstances show that. But in reality, we're kind of open to the public. We're wide open. So if anybody were to walk by and hear something, well, it's not like they're intruding. So that would mean that there is no expectation of privacy. So the circumstances to create the privileged communication doesn't exist anymore. Yes, there was rendering illegal services. There was a recognized relationship between the two, but there wasn't any circumstances. There was a third-party passerby that was allowed to be there. We were talking. They heard something. They're allowed to hear. You can't turn their ears off. That's your responsibility to be away from that situation. Now, if we were in one of those little hidden rooms, there's a lot of rooms that are called attorney rooms. If we were in one of those and we closed the door, yes, we're in the courthouse, and now we're behind closed doors in a public place. So now we've recreated our circumstances to show that we had an expectation of privacy. It was both subjective and objective in that anybody would think those two want some confidence. They want some privacy because they're talking about something secret. So we've talked about the attorney-client privilege. It's really just as simple as that. It's a lot more simple than the next one I'm going to talk to you about. And the attorney-client privilege, again, is just there has to be an attorney and there's a client. And we're going to keep it that simple. There's definitely some minutia, some gray area there that I'm not going to get into because your book doesn't get into it and you don't really need to know it. But just understand there has to be an attorney and a client, right? That's the relationship, and they have to be talking in a situation where, in a circumstance, there has to be an environment that shows that there was some sort of expectation of privacy. If there's a third party there that is necessary for legal services, that's fine. For example, what if it's a juvenile? The juvenile is my client, but the mom or the dad or the parent needs to be there so that they can talk with the juvenile. Now, I may ask for the parents to leave sometimes because the juvenile is my client, but the parents are necessary so that I can render legal services, so I can talk to them and they can understand because, sometimes the adults need to talk. So that's that circumstance. That's a circumstance where a third party can be there and it's not going to ruin the privilege. Now, for our second privileged communication that I want you to know kind of in detail, is what your book calls the husband and wife privilege. That is misleading because it's got two, actually. There's a communication privilege and then there's a testimonial privilege. And I want you to understand those differences. Distinguish the two in that way. Distinguish them. Understand that. That's how I can tell the difference. If I'm testing you on something, or you're actually in the field and you're looking at something and you're trying to determine which one is applying here, sometimes they both apply, but if you know only one applies, know that one's only for communications and one is for testimony. And communication privilege can be used to bar testimony from both, but what it's protecting is different. So what does this look like? For the communication privilege, the marital communication privilege, let's call it that, which is what it's really called. It is valid and it applies in a situation where husband and wife discuss things during the course of the marriage. And it can be about anything. The privilege survives the marriage, meaning if they divorce, it still applies in court. What does that mean? That means if I'm married to Jennifer and I have lots of communications and we talk about something that later on, after I get divorced, I'm being sued for, then if they call Jennifer in to testify regarding something that happened back when I was married and a communication between her and Jennifer, I could assert the marital communication privilege and say that was privileged communications. I made that during the course of the marriage and it wasn't relating to criminal activity. And the court would have to accept that. And I could bar Jennifer from testifying even though we're not married anymore. Okay, let's flip this now. Spousal testimonial privilege. It only applies in criminal cases. It doesn't apply in civil cases. That marital communication privilege example I gave you just a few minutes ago, that was a civil case. It applies in civil and criminal. The spousal testimonial privilege is different. It allows the spouse who is still currently married, you have to be currently married, to plead that testimonial privilege so that she or he does not have to testify against their spouse. What does this look like? I'm on trial for a crime in which they need my spouse to testify against me to certain facts and circumstances in order to prove an essential element of the crime. Doesn't matter what the crime is, just that's what has to happen. They have to use my spouse's testimony, who I'm currently married to prove that I did something wrong. And that would mean that she has to testify against me. They call her to the stand. They tell her to raise her right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? And she affirms, I do. She sits down. The prosecutor looks at her and says, so you're saying to me today that your testimony is A, B, and C, and that your husband A, B, and C this. And she will say, if she asserts, I assert my spousal testimonial privilege. What that means now is she no longer, it's the same as pleading the fifth, essentially. She no longer has to testify. She's not subject to cross-examination, and she will be dismissed. It's her privilege. She's allowed to do it. Now, here's the real catchy part. Let's say let's backtrack. Prosecutor asks that question, and my defense attorney gets up and says, she pleads the spousal testimonial privilege. Doesn't work, okay? It only works for the person testifying. So the person testifying has to plead the testimonial privilege. I can't do it, neither can my spouse. But the marital communication privilege, I can. So, recap. Marital communication privilege. It applies during the marriage. It protects all communication made between a husband and wife during the marriage. There's some exceptions. And that survives the marriage. If they divorce, it survives the marriage. So that either spouse ex-spouse actually, could still assert the privilege so long as the communication that they're trying to get was made during the course of a valid marriage. I'm not going to go into valid marriage because this is not family law. We're talking about only a valid marriage. That's the requirement. The spousal testimonial privilege, you still have to be married. So once divorce happens, it cuts it off. That means the spouse who's testifying, if they're divorced, they can't assert that privilege. It's only applicable in criminal cases, so that's the only time you oversee it. So many of you will see the spousal testimonial privilege, but you may never see the marital communication privilege because it may never come up in a criminal context. So there we are. Those are the three privileges I want you to know. I'm breaking husband and wife into two, meaning that there's three that you're going to need to know a little more detail. There are a couple other ones in there, like there's the patient and psychotherapist privilege. There's the clergyman and the clergyman privilege. And these are all, you could all sum these up and relate them to the attorney-client privilege. In that, as long as it's between the two, and it was made for the purpose of whatever I'm going to that person for, and it was made in a situation where I wanted some secrecy, the privilege will apply. Psychotherapist and patient, I'm at a psychotherapist's office, I'm sitting down in front of them, I'm expressing it to them. A lot of the psychology of what happens in my day-to-day life, that is protected as long as it's for the purpose of, furthering my treatment or obtaining a diagnosis, things of that nature. Same thing with clergymen. If it's for the purpose of furthering or developing or encouraging my spiritual development and it's in secrecy, it's going to apply. So any privileged communication can be summed up with the relationship and the circumstances. There are exceptions. Criminal activity is usually always going to be an exception. If there's criminal activity being discussed in communication, it's going to be an exception. There's some that it doesn't apply to, like the attorney-client privilege. If my client tells me that they committed the crime, I can't say that. Now, if they say things like, I'm going to commit a future crime, then we start talking a little bit different. But nonetheless, crime or putting someone else in danger are common things that are used to escape the privilege, so that the person who heard the privileged communication can then report it so that people can remain safe. That's chapter 10. Like I said, I try to keep it short and sweet, and I will see you guys next time for chapter 11.